He is now the managing editor of a collaborative book project at FACE. Gary contributes to Constituting America annually, a 90-day study project, has spoken on constitutional issues to regional and national conferences, and spoken before a committee of the General Assembly. For 2 years, he hosted a weekly radio show called We the People, The Constitution Matters, on a Philadelphia area radio show. Gary has been married to his wife, Phyllis, for 52 years. God bless you, and has 2 children and 7 grandchildren, all living in the local area. He can be reached by email, and the email address is here if you'd like to, contact him for an event near you. So with that, I'll bring up Gary.
Yeah, for Gary.
Take this in case you want to put your thing up here.
Well, greetings. I bring you greetings from the Breakfast Club system. How many of you have heard about Breakfast Club? That's like a tea party for breakfast. We meet once a week at a breakfast restaurant, and we discuss the same sort of thing that you do. It's non-affiliated with any party, but it is definitely conservative. So if you'd like more information, I can certainly share that after we're finished tonight. I gave the same presentation to a Raritan club on Monday night, and that was a little bit different than speaking to this group, because I know this group knows your Constitution and they know the values and principles of our founding period. So I can go a little bit quicker through this, and maybe we need to have some discussion. The 5 words or phrases in our founding documents that you should try to understand. I actually thought about calling this 8,923 words in our founding documents that you should try to understand. That coincidentally is the number of words in the Constitution and the Declaration of Independence combined. But I figured if I called it that, the room would empty out in about 30 seconds and I'd be speaking to myself. So we'll just focus on 5, see if that works for us. So Jefferson famously said, if a nation expects to be ignorant and free, it expects what never was and never will be. A nation can't continue to exist if its citizenry is ignorant of its founding principles, ignorant of the structure of its government and how it's intended to operate, et cetera, et cetera. So we here do have a problem. Houston, we have a problem. 10% of college graduates believed in 2016 that Judge Judy was on the United States Supreme Court. In 2011, 38% of Americans failed the standard citizenship test. In a 2016 poll, 39% of Americans were unable to name any of the 6 different rights outlined in the First Amendment. 41% of Americans couldn't name the vice president when Joe Biden was the vice president. 64% of Americans in 2014 couldn't name all 3 branches of their government. That's pretty basic, isn't it? And 64% of Americans couldn't name all 3 of those branches. But it was not always this way in this country. In 1831, when Alexis de Tocqueville took his famous tour across America, he found, and he wrote in his book, every citizen is taught the history of his country and the leading features of its constitution. It is extremely rare to find a man imperfectly acquainted with all these things, and a person wholly ignorant of them is sort of a phenomenon. Well, not today. It's sort of a phenomenon to find someone conversant in our founding documents and the Constitution. So we're going to look at both these documents because there's a definite link between these two, the Constitution and the Declaration. Normally, every July 4th, we dust off the Declaration and we have somebody read it, and we have some fireworks, and then we set it aside for the next 364 days. But I'm here to tell you, and the Supreme Court is going to back me up on this, that the Constitution and the Declaration go hand in hand. It's folly to study one of them without the other. Let's look at why I say that. In 1814, the Declaration was placed in the US statutes, along with all the other laws of this country by Congress. In 1878, the Declaration, the Northwest Ordinance of 1787, the Articles of Confederation, and the Constitution, those four documents were tagged as the organic laws of the United States. And notice there's no hierarchy there. All four of those documents are on an equal status as being organic law of the United States. Declaration is equally organic law, as is the Constitution. What is organic law? Black's Law Dictionary says the fundamental law or constitution of a state or nation, written or unwritten, the law or system of laws or principles, and I've underlined that, which defines and establishes the organization of its government. So it is the principles of government. You won't find too many of those principles verbatim or blatantly written in the Constitution, but the Declaration has those principles of government that we need to understand to properly interpret the Constitution. In 1897, the Supreme Court inexorably joined these two documents. They called in a decision, the citation of that decision is rather obscure, but they called the Declaration of Independence the thought and spirit of our government, while the Constitution is the body and letter of the government. So it doesn't make any sense to just study the body and letter of a government system without studying the thought and spirit behind it, correct? You with me on that? Good. So
where does the Bill of Rights fit into that?
It's part of the Constitution, obviously, and it comes later in 1791, after the Constitution is ratified. Thank you for bringing that up. I write a weekly essay for the Breakfast Club system, and I am nearing the end of having gone through all 25 rights outlined in the Bill of Rights. And it's an important part of the Constitution, to say the least. But at the beginning, it was not part of the original Constitution. So Madison tells us that every word in the Constitution decides a question between power and liberty. So there really are no extraneous words. You need to understand all those words to make sense out of them and to decide where the line between power and liberty is to be drawn. So how do we know what these words written in 1787 mean? We have two good sources. We have a 1755 dictionary put together by Samuel Johnson. It exists in paper form and it exists online in an online version. You can sit there at your computer. You can look up the definitions of these words in 1755. We also have Webster's famous 1828 dictionary. That also is available in printed form and online. The online version is an abridged version. It doesn't contain all the words in the printed dictionary, but it's certainly a helpful tool when you're sitting there trying to compose an essay at your computer. So let's look at the first word or phrase that we really need to understand. All men are created equal, endowed by their Creator with certain unalienable rights, but among these are life, liberty, and the pursuit of happiness. Well, if we look for the word unalienable in Johnson's dictionary, we don't find it for some reason. I mean, it was a commonly used word at the time. For some reason, Johnson omits it, but Webster does not. The definition is not alienable. Well, that doesn't help us too much. That cannot be alienated. Again, not too helpful. Something that cannot be transferred, as in unalienable rights. So there's a little more meat to it. So unalienable rights are a gift of God, an endowment of God, and they cannot be transferred. But wait a minute, if I have a right to liberty, how come I can be put in jail? Well, these rights cannot be transferred. Even in jail, you retain a right to liberty, but you're there because you forfeited that right by breaking a law and having a penalty imposed upon you. So these rights are not transferable. They cannot be taken from you, but you can certainly forfeit them through your actions. Jefferson reminds us in the only book he ever wrote, Notes on the State of Virginia, can the liberties of a nation be thought secure when we've removed their only firm basis, a conviction in the minds of the people that these liberties are the gift of God? that they are not to be violated, but with his wrath. Indeed, I tremble for my country when I reflect that God is just, that his justice cannot sleep forever. Pretty powerful words. So these unalienable rights need to be first and foremost in the minds of the people. How do they get there? Well, they're taught to people students coming through the educational system. Or their parents teach them, but these concepts, these rights, inalienable rights, need to be kept alive in the minds of the people. Because when they are violated, if they are violated, God takes notice of that, in Jefferson's words. So a couple questions I would pose to us. Do we have unalienable rights or don't we?
Absolutely. Yeah, of course.
Okay? If we have them, where'd they come from? Jefferson provides us the answer.
Creator.
Are these the only rights we have? Okay, if these are not the only rights that we have, where did the others come from?
They follow.
Government, absolutely, government can create rights. What is the right to vote? Is that a natural right?
No.
Or is that a civil right created by civil government? Is your right to vote unalienable?
No.
No, absolutely not. The right given to you as you turn 18 can be taken away if you become a felon. So that is certainly not a unalienable right. So we have, you see, two distinctive categories of rights. We have unalienable rights, natural rights gifted from God, and we have civil rights created by our government. It's very important that we keep those two categories distinct. Question?
What happened for the right to distort it?
Good question. What happens when they're distorted? Well, we have to have a correct understanding of what that right entails to know first that it has been distorted. So it begins by knowing these rights in their original conception and what they included as they were originally created by God. So let me just stop there and well, one more question and then I'll give you a little insight here. Does the government grant rights? We've already answered that. How do we distinguish rights granted by government and those granted by God? Well, if they're alienable, they didn't come from God. Now, everybody understands the concept of natural law. We're going to study that in just a moment, but natural law was created by God to give human beings guidance on how to get along, how to have a happy life, how to have a fulfilling life. Natural law are the guideposts, the guardrails, if you will, to guide our behavior. Out of natural law are derived natural rights. Now, Blackstone says it very clearly in his commentaries on the laws of England. He said, God, in concern for the frailty of our reasoning capability, and I'm paraphrasing him here, took a portion of natural law and revealed it to us as revealed law in the Bible. So when we think of the Ten Commandments, that is God's revealed law. It was originally part of natural law, and it still remains, in a sense, part of natural law. But it becomes revealed law by being revealed in the Ten Commandments. Now, until when there was no statute law, people went to court over various and sundry controversies, and judges had to make a decision because there was no law guiding the circumstances that they were facing. So judges had to reach into natural law and make a decision based on fairness and reason and guidelines of natural law. Those decisions over time became what we call common law. Everybody heard the phrase common law? Okay, so common law is a collection of judicial opinions and judgments based on natural law. Then, as assemblies or legislatures begin to create statute law displaces or replaces common law. So at one time in our country, common law was a significant part of the legal structure. As more and more statute law was created, it replaced common law. So we have natural law at the very beginning, it feeds into common law. Common law eventually gets replaced by statute law. That's kind of the broad expanse look at the structure of law. So is government instituted to secure our rights or not?
Yes.
Yeah.
Jefferson clearly says so. For this purpose, governments are instituted among men, deriving their just powers from the consent of the government. All right, let's look at another phrase we encounter in that same document. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to this separation. So Jefferson refers here to laws of nature and nature's God. Laws of nature and laws of nature's God. Where do we find laws of nature's God? Bible. Okay. Laws of nature are not written down. This goes back to what Blackstone referred to. God was not quite sure that in our flawed reasoning capability, clouded by sin, that we would discover through reason and exploration and investigation all of the laws of nature. So he takes a portion of those laws and reveals them to us in the Bible. And so we have the laws of nature and we have the laws of nature's God. And that is what Jefferson refers to here. So Jefferson understood that based on natural law and revealed law, we have not only the authority to separate ourselves from a power on the earth, the British government, but we also have a responsibility to declare why we are doing this. He finds that in natural law. Hamilton's view, not much different. Good and wise men in all ages have supposed that the deity has constituted an eternal and immutable law, which is indispensably obligatory upon all mankind. Indispensably obligatory. All people, all human beings are required to obey natural law. And this is prior to any human institution, whatever. Right? Natural law existed prior to the very first government ever being set up. This is what's called the law of nature. On this law depend the natural rights of mankind. Yes.
What if they interpret it differently?
Aha, it's an important point, and we have a problem. But then the people who are interpreting natural law need to understand the mindset, the worldview of the founders of this country who relied upon natural law as they put together this governmental structure. So we have to get people who are in the business of interpreting law to understand things, to have the same worldview that our founders did. And that's not hard to do, but it does take some effort, some purpose to do that. So great and wise men throughout the ages, and Jefferson, Hamilton, John Locke, Sir William Blackstone, Samuel Pufendorf, Hugo Grotius, Baron Montesquieu, Emmerich Vattel, all these gentlemen expounded upon natural law. So we're not talking about just America's founders, we're talking about all the political philosophers of this era had the same basic mindset of what natural law was and the place that it plays in our governmental system. So if the laws of nature do not exist today, what caused their demise? Politicians is a good answer, yes.
No.
People's ignorance.
Yeah, not understanding.
People's ignorance caused the demise. Well, to be fair, natural law didn't go anywhere. Okay, natural law is still here as it ever has been since the creation. What went away was our understanding and our use and our reference to natural law. We allowed it to be erased from the landscape by just setting it aside, not thinking about it, not talking about it, not referring to it, not insisting upon it as the basis for our rights. So we were complicit in making natural law less of a thing today. Blackstone says this law of nature is, of course, superior to any other. No human laws are of any validity if contrary to this, and such of them as are valid derive all of their force from this original. So human laws, obviously created by legislators, elected by the people for that purpose. Human laws must have validity, and if they are contrary to natural law, Blackstone says they aren't law. They are null and void. They have no force. They have no legality. So how do you know whether a statute law, a civil law created by man, violates natural law? You have to study natural law. You have to know what its principles are. And as I said, we have a good portion of natural law that has been revealed to us in terms of how we are to interact with our fellow human beings. Another phrase from the same document. Among these inalienable rights are life, liberty, and the pursuit of happiness. Now, Jefferson departed from the normal way of describing those the three primary rights. All the other documents from the colonial period, you find the Stamp Act Congress resolves, the First Continental Congress resolves. All of them refer to life, liberty, and life, liberty, and money. Close. Life, liberty, and property. Property. You'll find this throughout all the founding documents until 1776. Every other writer says life, liberty, and property. Find John Adams, Samuel Adams. You'll find the two Congresses I mentioned, all saying that our essential rights are life, liberty, and property. Jefferson says, no, wait a minute. Life, liberty, and the pursuit of happiness. What's he mean by that? Because that is a radical change to what the colonists were used to hearing. And we don't even know from Jefferson's notes where he got the phrase. We think it comes from Locke because John Locke did use that phrase, but other Enlightenment philosophers use that phrase as well. But we do find some hints in others of Jefferson's writings. He says, happiness is the aim of life. Virtue is the foundation of happiness. So if we're pursuing happiness, what are we really pursuing, according to Jefferson? Virtue, absolutely. A virtuous life is what Jefferson said is the pursuit of happiness. Pursuing a virtuous life. What is virtue? How do we define virtue? Bible. Well, the Bible has some great examples of it. Basically, virtue is doing what is right. Doing what is right and proper. If we all did at all times what is right and proper at that particular moment, what does Madison say? If men were angels, no government would be necessary. If angels were to govern men, no controls on the government would be necessary. But in devising a government to be administered by men over men, the great challenge is this: you must first empower the government to control the governed, and the next place you must oblige it to control itself. So yes, we need to pursue a virtuous life. We need to pursue and try to figure out what is the right thing to do in every circumstance. We're going to fail because we're not angels, right? Last time I looked, we're not angels, so government, according to Madison, is going to be necessary. But a virtuous life is the pursuit of happiness. The pursuit of a virtuous life is the pursuit of happiness. Edward Cook, the great English jurist, says, a legislature must not obstruct our obedience to him from whose punishments they cannot protect us. That makes sense? See it? Yes. Legislatures must not put barriers in front of us from obeying God's commandments.
When did he say that?
I can get you the quote, I don't have the citation with me, but I can get it for you. So a legislature must be very careful to not place barriers before the people that prevent them from following God's instructions, God's natural law, God's revealed law. Because the legislature obviously can't protect us from the wrath of God when we go astray. All right, let's switch documents now and look at the Constitution for a couple of words that we need to definitely understand. In Article 1, Section A, Clause 1, we find the Congress shall have power to lay and collect taxes, duties, imposts, and excises. For what purpose? To pay the debts and provide for the common defense and the general welfare of the United States. What is general welfare? How would you define general welfare today? Anybody? What?
Department.
Wow.
Wow.
Department of Defense.
Everything they're calling it.
Yes, all right, let's take, what is the common definition of general welfare today?
Social well-being.
Social well-being. Okay. Social well-being of whom? Yes.
Well, what happens when the government goes against these rules? Welfare.
You're getting ahead of me by 2 slides. We're gonna get there. That's a very good question. General welfare in the founding period meant something that enhanced the welfare of all Americans. Every American, all Americans. If it improved their welfare, that was general welfare.
For everybody, not just a group.
Not just a favored group or an individual, etc. And then I'm going to show you some examples of that. Madison was very bothered by this phrase in the Constitution. And after he was elected to Congress in the very first Congress, he got to see firsthand how this phrase could be exploited and its intended meaning modified. And he says in 1792, the 3rd year of his term as a congressman, if Congress can do whatever in their discretion can be done by money and will promote the general welfare, the government is no longer a limited one possessing enumerated powers, but an indefinite one subject to some particular exceptions. In other words, if Congress uses this phrase general welfare as the basis for their spending, and they're allowed to define what general welfare means, is there anything that Congress can't spend money on?
No.
And they constantly do.
Well, and we're gonna find out how they got the authority to do that. And it wasn't just by thinking of this phrase differently than the founders did. So the very first Congresses actually took the phrase, the view that general welfare had to be something that enhanced the welfare of everyone. It was distinct from specific welfare or targeted welfare, welfare to this group or that group. The very first Congress was asked to make a loan to a glass manufacturer in Georgetown, and they turned it down. Why? Why did they turn down this loan? It was unconstitutional. Why was it unconstitutional? Because this was a Congress of specific and enumerated powers. Where in the Constitution does it say Congress has the power to make a loan? Nowhere. It's not in there. So these gentlemen said, we can't cover it by the general welfare phrase. This isn't general welfare. Whose welfare is being enhanced if we grant this? One man. Right?
Yep.
this can't possibly be general welfare, so it can't be covered by the general welfare clause. And we look at the Constitution, we find there's no authority to grant loans in here. This Constitution is one of limited and enumerated powers. If the power is not enumerated, if it is not written, we don't have it. That's what the 10th Amendment tells us, right? So the fourth Congress, 6 years later, fourth Congress, Savannah, Georgia, encountered a fire that burned a third of the city. People were desperate. They were without homes, they were without food, they were without clothing, some of them. They pleaded with Congress for some aid. Congress said, we'd love to help you. We don't have the authority to do that. Nowhere in the Constitution does it say we can send you aid. Can't be covered under the general welfare clause because it is just you people of Savannah. Now, today, would we blink an eye at sending billions of dollars down to some disaster somewhere? No, we wouldn't have a second thought about doing it. But the very first Congresses did have a problem with that because they took a correct view of what general welfare is. And they took a correct view of enumerated powers. Now, let's see how. Another point, many presidents have vetoed multiple private relief bills passed by Congress. Grover Cleveland was notorious for doing this. So we come to 1936 in a case called U.S. v. Butler. And in that case, we find these words by the majority of the justices. The General Welfare Clause confers a power separate and distinct from those later enumerated. It is not restricted in meaning by the grant of these enumerated powers. Take that, Jimmy Madison. They didn't really say that, but that's what I surmise they meant. And Congress consequently has a substantive power to tax and to appropriate it, limited only by the requirement that it shall be exercised to provide for the general welfare of the United States. Okay, great. What is the general welfare of the United States? A year later, in Helbring versus Davis, which sanctioned social security, Congress, the court says Congress may spend money in aid of the general welfare, where their intent is where the line between specific and general welfare shall be placed cannot be known through a formula in advance of the event. The discretion belongs to Congress. Boom. Boom. If Congress has the authority to decide what is general welfare and what is not, and if Congress has the authority to spend money on that thing that they decide is general welfare, tell me what Congress can't spend money on. There is nothing that they can't spend money on. And they do. They spend money on everything. Because the Supreme Court has said, this is okay. This is how you should interpret the Constitution. 1937, Congress was given this absolutely unrestrained power to spend money.
Just briefly, some of these things that they spend money on, we like. I
yes.
like the space program, right? But there's no authority to send men to move in the Constitution or elsewhere. How do you think what we're doing? What percentage of this spending that's extraneous is good and what is waste?
We have forgotten the first three words of the Constitution. Who is the ultimate authority
We have people.
over this interpretation of this document? Yeah. And so when we send people to Congress, we cross our fingers and we hope that they will take a founder's view of the Constitution as being one of limited and enumerated powers. And when they get there, my first meeting with Rob Whitman, many years ago, I think it was 2012, went into his York County office, sat down and said, I'm going to start teaching the Constitution. And he said, just a moment, let me get something for you. He went to the back office and he came back out with this 6-inch thick book. It's called the US Constitution Analysis and Interpretation. You can buy one from the government printing office. And it cost me $290. Today you can get one for about half that. And there's an online version. But it is the compilation of all relevant Supreme Court decisions about how the Constitution should be interpreted. And in there, you find that the Supreme Court has given the Congress the authority to spend money on anything. Yes.
What happens when you have a Supreme Court that has a distorted view?
What happens if you have a Supreme Court that has a distorted view of the Constitution? Everybody has heard the phrase living Constitution, correct?
Yeah.
Yes. And how many Supreme Court justices currently sitting on the bench believe that the Constitution is a living Constitution?
Maybe 4.
3 to 4-ish.
Yeah.
Yes. So that's what happens when you have Supreme Court justices confirmed to the bench who don't have the founder's view of this Constitution. You have decisions which expand the power of government. Fortunately, those 3 are in the minority right now, and so we are seeing some very good decisions coming out of this court with a 6 justice majority. A wishy-washy Chief Justice.
Yeah.
But we're very hopeful that this continual rollback of bad decisions from the past will continue. And this is certainly one of them. This decision in 1937 certainly is a terrible decision. Because we see the result. The result is they're bankrupting us. They're spending money without any regard to how it's being paid for or where that money is coming from. And if they can't get enough countries and institutions to create debt, then they print the money anyway, right?
Mhm.
So this is the result of unrestrained spending. So either we accept a Congress that can spend money on anything it wants, or insist it only spend on enumerated objects. Well, good. How are we going to do that? How are we the people going to do that? The 30 or so people in this room aren't going to change that paradigm by themselves. We're going to have to train and teach a lot of Americans what has happened to their Constitution while they were sleeping. And the young people coming up through public school are not going to learn this. So we have a big job ahead of us if we're going to train up a generation that understands the Constitution the way the framers of that document understood it.
Oh, I haven't-
So either $32 trillion in debt is a problem or it's not. If you think it's a problem, then we have to get people elected to Congress who believe with us. The final phrase or word is commerce. In Article 1, Section 8, we also find the word that Congress has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Now, Webster's and Johnson's both have a definition for the word commerce. Webster's calls it an interchange or mutual change of goods, wares, productions, or property of any kind between nations or individuals. That is commerce. So I ask you, is growing wheat commerce?
Yes.
Is growing
Oh,
wheat
growth.
commerce? An interchange or mutual change of goods, wares, productions.
No.
Is there any interchange going on here?
No,
If
no,
I'm growing wheat for my own cows.
no.
Is manufacturing a chair, is that commerce?
No.
Yeah. When does it become commerce?
When you give it to another person.
When you give it or sell it to another person. Is the manufacturing of something commerce?
No.
Is the selling of that thing commerce?
Yes.
Okay,
But if you, the problem lies is that you do not have the raw materials at your disposal. You have to bring them in. So it's commerce from other people bringing them in to manufacture, and then you bring stuff and sell it out. That's where they get that.
Does Congress, according to the words in this first bullet, does Congress have the authority to regulate all commerce?
Yeah.
No. What commerce can Congress
Foreign nation,
legally regulate?
Not inter.
several.
Commerce with foreign nations,
Right.
commerce with Indian tribes, and commerce that goes across state lines.
With other governments.
Commerce among the several states, not in the several states, among the several states. Commerce that, it's called the Interstate Commerce Clause for a reason. Okay, that was the intent. Congress, if you look back at the Articles of Confederation period, the problem Congress was trying to, the framers were trying to solve here was that the states were putting trade barriers against each other's commerce. We have to give Congress the ability to regulate that trade between states. So how did we get to a very limited view of what commerce is when it's interstate? To now today, Congress can regulate anything having to do with business.
Took away states' right.
Well, I'll say this. One, if you are producing everything within yourself, okay? You plant it, you grow it, you don't buy anything else, like back in the farmers, they kept their own seeds, they did everything within themselves. They had their own cows, they had their own stuff. Until they sold it, it didn't become commerce.
Okay,
Well, now, any manufacturer in any location has to buy from another state or has to buy from another country. Therefore, it becomes commerce coming to them.
yes, it's
So it
regulated.
regulates coming to
Okay.
them, and then they gotta do it, okay, I'm building it and making it, and then they gotta sell it, and it goes across state lines. So it's commerce in a loop, and that's where they get that.
Well, let's take your example then. I'm a farmer, I wanna grow some wheat and feed it to my own cows. I need to buy the seed. Is Congress able to regulate the sale of that seed across state lines?
Yeah.
Yes.
It is.
Absolutely they are. Now the seed is mine, I've paid for it. I put it in the ground, I grow my wheat, and I'm about to feed that wheat to my own cows. Congress in 1942 says, well, we're gonna regulate that feeding of the wheat to your own cows. 1942, Wickard v. Filburn. Poor farmer Filburn was given an allotment of wheat by the Agricultural Adjustment Act. You may grow this much wheat and no more.
We do that.
He said, well, that's another story, but he said, okay, I see that allocation that you've given me, but I want to grow another 10 acres of wheat and feed it to my own cows. He said no. They said no. And he says, where do you get the authority for that? They said, the court, in the court decision, they said, if we let you grow that extra wheat for your own cows, then you wouldn't have to buy it on the free market. In other words, your growing of that wheat is going to influence the interstate market in wheat.
Ridiculous.
And because of that influence, then Congress has the ability to regulate it. That is the logic of Wickard v. Filburn. And if that is the logic, if you can trace some connection to an interstate transaction, then what is not interstate commerce? Everything is interstate commerce. If you only need to trace some connection to where an actual interstate transaction took place, then everything becomes regulatable.
Is this where we stand today?
This is where we are today, yes.
They
And so everything is regulated. Everything is regulated because everything can be traced in some remote way to an interstate transaction. We are such an interconnected society that interstate transactions are happening way out in the foggy distance that we can't see. And that is all the connection Congress needs to regulate whatever they want. They regulate our advertising, our employment, our labor, our environmental compliance, our safety and health. They regulate our privacy. And the compliance costs with these regulations and the reporting of the compliance of these regulations costs $2 trillion every year.
Wow.
Who pays that $2 trillion? You do, I do, everyone does. No business in their right mind is going to absorb the costs of compliance with regulations. Every bit of that, every penny of that is passed on to you in the cost of the goods that they provide. Yes.
My son-in-law, his family owns like 100 acres out in central Texas, where they are paid annually by the federal government to not do anything with it. They don't grow anything, they don't plant anything, they don't raise cattle on it, the land just sits there and they don't pay to not do anything.
At least they're paid.
Wow.
Can you imagine being told you can't do anything and we're not gonna, you can't do anything with it, we're not gonna pay you.
And
So
It's absolutely insane. And then the farmers, when the market goes, maybe international market goes big, then they just throw more money at the wheat growers because they didn't get the baseline price for the wheat.
So, what if we amended the Constitution to say that commerce in this clause of the Constitution shall be intended to be confined to an actual interstate transaction?
Has anyone tried that?
Well, stay with me. If we amended the Constitution to narrowly define the word commerce in this clause, would that be helpful?
Yeah,
Okay,
they get around it.
It'd go back to state rights then.
okay, a lot of it would go back to state rights, yes. Anything that stayed within a state where there was no interstate transaction would certainly be untouchable by commerce. So if we agree that a modification of this clause through the amendment would be helpful, that leads us to the next question. How do we amend the Constitution?
This Article 5.
Article 5 describes how many ways of amending the Constitution? Two. And Article 5 describes how many ways of ratifying a proposed amendment to the Constitution. Two. So there are basically 4 different combinations of those 2 methods. What is the first method of proposing an amendment to the Constitution?
Congress has to pass.
Congress.
Yeah,
Congress, every day of the week, any day of the week. Congress could propose an amendment to the Constitution. They must pass it with a 2/3 vote of both houses. And then it must be sent to the states for ratification. Whereby it becomes effective if how many states ratify it? No, 3/4, 38 states. What is the second method of proposing an amendment? Convention of States, also mentioned in Article 5. If 2/3 of the states, that's where the 2/3 come from. If 2/3 of the states apply to Congress for a convention, then those states, well, if 2/3 of the states apply for a convention, then Congress shall, the words in the Constitution, shall call the convention, at which the states can propose an amendment. And then it must be, once again, ratified by 3/4, 38 states. So if we agree that an amendment to this clause, clarifying the understanding of the word commerce and limiting the power of Congress to use that word in regulation, would it be helpful?
Yeah.
Okay. Is Congress ever going to propose such an amendment? Why would they? Absolutely. All right, so I think you see where we're going. We've got words and phrases in the Declaration of Independence and the Constitution that are key to understanding the principles and limitations of the government that were intended from the outset. It's also important to understand how the interpretation, the original interpretation of these words and phrases has changed. And who changed it over the years? In almost every case, it's been the Supreme Court granting an expansive understanding of that word or phrase and granting the Congress or the federal government more power in doing so. But in some cases, we have forgotten original understandings of these words and phrases. You know, we just move along with society, don't we? We just assume what is a man? What is a woman? We've lost a lot of definitions, haven't we? So part of it is our education and our maintaining these original understandings of words and insisting that our elected representatives use them as well. Your question?
Yeah, is there a difference between the words shall or must?
I'm not a lawyer, and I proudly say that, so there may be a legal difference between those two words, but I'm not aware of one. Shall and must. They seem to have the same definition in my mind.
Are you taking general questions?
Let me leave you with some parting words, and then I will. One of my favorite sayings, John Jay, our first Chief Justice of the Supreme Court, one of the three writers of the Federalist Papers, when he was a judge, actually in the Supreme Court of New York, and he was charging a jury in 1777, he said, "Every member of the state ought diligently to read and study the Constitution of this country and teach the rising generation to be free. By knowing their rights, they will be better prepared to, they will sooner perceive when they're violated and be better prepared to defend and assert them." So who is he talking to? The people of 1777?
We the people.
He's talking to we the people, yes. Every member of the state. And notice, he doesn't say you just read your Constitution, does he? No, he says what? Read diligently and study diligently your Constitution. It's not enough to just read it. You have to diligently study it. And then you're not done. Because then you've got to teach. Now, does he say every member of the state ought to read and study the Constitution, and then only the teachers need to teach the rising generation to be free? Does he say that? No. Everyone has this task of teaching the rising generation to be free. By knowing their rights, that we sooner perceive when they're violated and be better prepared to defend and serve. Only a well-instructed people can remain a free people. So now I will take general questions. Yes.
I would really like to know what you would say to a confrontational person in your face who says, how can you venerate any of these conclusions you're drawing because they were written by those slave.
How many men in the Constitutional Convention owned slaves? That's the first question. Not all of them, no. About 25 out of the 55 gentlemen had slaves. And then we have to go back and figure out how they came upon those slaves. In almost every case, they inherited them when their father died.
That's not adequate for me as
Okay.
a guy who's
Well, first of all, we have to contend with not all of them were slaveholders. So how do you distinguish then the words and the effort of the non-slaveholders to this document? Certainly, if none of them were slaveholders, would you accept this document?
But, I suppose maybe, but I mean, they lived in a society that held slaves.
Right. But they weren't all slaveholders, and if you're going to taint this document based on some of them being slaveholders, then how do you distinguish what was produced by the non-slave holding delegates versus those that were?
Okay, so that's how you would respond to it, and then the person would say to you, by granting former slaves citizenship, right to vote, did they suddenly inherit, uh, unalienable rights?
They had unalienable,
Could they have had unalienable rights, not had them before, but had them after? That's for the challenge.
They always
That
had-
the slaves always had unalienable rights, and Jefferson would have been the first to concede that. In fact, that quote I gave you from Jefferson's notes on Virginia, he trembled when his country, for his country, they considered that God is just and his wrath will not be stayed forever. He was talking about slavery
Himself.
He was talking about himself and slavery. He recognized that slavery was a moral wrong. And they all did. They all recognized it as morally wrong. They couldn't figure out a way of ending it without bringing down the entire country, the entire economy. Madison was 51 years old when his father died in 1801, and Madison then was now responsible for the slaves that his father owned. And he had an estate to maintain. What was he to do? And he was a sitting congressman. What was he to do? So there's a lot to this story that people tend to overlook when saying, well, these are tainted documents because those gentlemen were all slave holders. And even if they were, all of them, what does that do to the principles that are embedded in this document? Are you trying to tell me that all of these principles are counterfeit because someone owns slaves?
There are people who would say that.
Yes, well, I think they're going to say that, and you need, there's a lot there. You want me to come back and teach you about the slave history of the country? I can do that. Because there's a lot to this story, and there's a lot of ways to deflect this charge that it is a tainted document because some of these gentlemen own slaves. Questions?
Well, the thing I'd come back with them, and if you could prove that we started slavery, right?
Yeah,
That
that's,
slavery's been around since the beginning of man.
Yep.
Right? And the fact that slavery exists in the world today, and that the people that sold the slaves to a majority of the people that brought them over here were African Americans.
I have
They
a
were tribes and everything else that started.
how many of you,
Yeah, not half that. They took the people, they did the slaves and sold them for whatever they wanted, trinkets or guns or whatever. And that also, I think I remember, the first person in the United States that owned a slave was actually
an African American, yes, a black.
okay.
How many of you heard of the 1619 project?
Oh, yeah, that's bad.
I've got a presentation on the 1619 project and putting right all of its
Yeah.
inaccuracies.
Sad.
When,
I'll be glad to bring that to you sometime.
where's your presentation? Oh, I thought you said you had one scheduled.
I have one in my hip pocket.
Oh, okay.
He has a lot of presentations.
So,
Excellent.
any other general questions on the topic at hand tonight? Yes.
Thank you. I enjoy hearing about the Constitution. Here's this video, and it's the confirmation hearing of Clarence Thomas. And that idiot, Biden, is the chairman of the judiciary. He brings up national law. He goes over national law to do this, national this is right, left. And then they talk to Clarence Thomas and privately, later, you know what he's talking about. I have no idea what he's talking about. He has no idea what he's talking about. And it was interesting because I always wondered about national law, but you clarified a lot of it. And really, natural law is pretty black and white.
There are a lot of great books on natural law. J. Budzetsky has written several of them. He's a Notre Dame professor. I highly endorse his books. I'm reading one right now on natural law, common law, in Korea. So, it's not a mystery
It's not something
It's not a
you could
mystery.
use. It's not something you could use for your position if you take the true definition of natural law, right? I mean, you can't make natural law left. You can't make natural law right.
No.
Natural law is
Natural law, right. Joseph Story, one of our first, eminent Supreme Court justices, was very famous in saying that natural law provides the understanding of statute law, and in fact, natural law is enforceable. Principally in the law of nations, where it was strained to, but there's a lot to this subject, and you have a question.
Oh, yeah, I have a question. So if our government is bankrupting us,
Yes,
is that general welfare of Americans?
doesn't
I
seem,
mean, can
doesn't seem
we-
like it, does it?
Can we take our constitution and start
All right,
questioning them on this?
here's
And-
what I tell groups. I'm walking around, I'm giving the camera that fits. All right. How many of you have been to a candidate forum? Okay. How many of you have ever heard someone ask this prospective candidate, what's the purpose of government?
Oh, yeah.
Yeah.
How do you understand the general welfare clause? You're gonna be passing laws based on this provision in the Constitution. What's your understanding of this? How do you understand commerce? And what is interstate commerce to you? You're gonna be passing laws based on this authority in the Constitution. Do you understand what you're gonna be doing?
They're never gonna know what general welfare law is. You could ask them that. I mean, that's.
Well, my point is, we're not asking the right questions
exactly.
to people
Right.
who are candidates for elective office, whether it's state or federal. Because our state elected representatives need to know the Virginia Constitution better than they know the United States Constitution, amen?
Amen.
So, we're not asking the right questions. If people understood that when they file for a candidacy, they're gonna be grilled on the Constitution, whether it's state or national. If they understand they're gonna be grilled on this, at the very first forum they undertake, you think that would do something to their preparation?
Yeah.
Would that change the way they prepare for these meet and greets?
They have to take that oath of office too,
Yes,
That oath of office for the school board. They are to support, defend the Constitution of the state of Virginia and the United States. They have no clue, because everything they're doing is against all those documents.
and they don't have to have a clue because we don't ask them that question. Explain what this means when you take an oath to support and defend the Constitution of the United States. Explain to us what that means.
Yeah.
And then, if we don't get a very good answer, what do we gotta look for better candidates. Question.
Well, I just have more of a statement that has to do with school boards. I'm working with a lady in Ohio, just to give everybody a little bit of, hope. And she is a grandmother, and she went to the Department of Education, Ohio Department of Education, not the school board, and presented them with constitutional questions and accused them of not following her constitutional rights. And they didn't reply to her, and they had 15 days or 30 days, whatever it is, to do so. So she filed a complaint with the AG and the governor. And right now she spoke to the governor's office for quite a while the other day. And they are in a scramble because she's got them against the wall. And she used her constitution, and she is not a lawyer. She was a housewife, and she's a grandmother, and she researched it for 2 years. And it's amazing. So she's using her constitution
There's a
to make things right.
favorite saying of Sam Adams: it doesn't take a majority to prevail, but a minority keen on setting brush fires in the minds of men. So all it takes is one person keen on setting brush fires in the lines.
Yeah.
So yes, one person can make a difference. Robert.
Gary, wouldn't you say, would it be fair to say that in the last couple of weeks, last several weeks, there's been some monumentous,
Momentous.
Monumental.
monumentous decision, and they've reversed
Yeah,
some wrongs that were done in the past to
absolutely.
set aside the for people who are of color, nation, whatever. And then, of course, the loan situation. And then the third one was what was
The
it?
303 creative, the right of conscience to not create a website.
Yeah, the Baker thing and all of that.
Right.
And these are great decisions.
Yes,
They would have never been made without the five.
yes,
So, I mean, eventually,
and the 3 that Donald Trump put there.
yes, and all that would have to be done is people just to read, not yours to give. By Daniel Boone, David Crockett,
David Crockett.
remember that story
Yeah,
of the
that's
fire?
very
I mean,
nice
that
little-
was everything, so.
But
we're going down
everybody
a very.
realizes, I hope, that the Supreme Court cannot go out precedent hunting and just
Right.
look for things to overturn. They've got to wait patiently while cases and controversies bubble up through the appeal process. And those cases and controversy have to be very precisely configured to allow them to go and target that precedent. So they have to be extremely patient that these cases will reach them and allow them to overturn some of these terrible decisions of the past. Yes.
Are any decisions forthcoming on, interstate commerce, for example?
No, not that I'm aware of. But that's a good point, because we need to get some cases up there that they can use to review Wicker v. Filbert. It was a terrible, terrible decision. And if we can get a case to them, then we won't have to amend the Constitution to change the word, the
Yeah.
meaning of the word commerce, etc. So,
Right.
all right.
You still do the constitutional classes? I remember
Yes.
way back when, yeah, it was an all day thing.
It is an all-day thing. I'm doing one in August out in Western Virginia.
Let us know when you're gonna do one here. We can let everybody know if they wanna go. What does it cost now?
$40.
$40. Where if anybody wants to attend.
All day.
Where Lester Coffee.
Port Royal? No, that's not right. Rocky Mountain. It's out west of
Yeah.
Lynchburg area.